Very good evening to one and all present here in this virtual meeting. First of all, I welcome you all to this virtual meeting, and I also welcome today we have with us a very renowned personality in the field of copyright, and that is Madam Naomi Korn. I request all the participants who are joining today in this virtual meeting to join me to welcome Madam Naomi Korn. And I would like to brief about her before we start the session. Madam Naomi Korn is founder and managing director of Naomi Korn Associate. She is one of the UK leading expert in copyright, data protection and GDPR, rights and licensing. She is the founder of Naomi Korn Associates and has been supporting the public, corporate, education and charity sectors on right management and right exploitation for the last 20 years. She is the former chair, Libraries and Archives Copyright Alliance, LACA, from 2013 to 2017. During this period, she led the reform of the UK copyright laws on behalf of the cultural heritage sector, resulting in new UK expectation to copyright in 2014. She has also regularly represented the interest of the sector to UK government ministers, and she regularly sits on government advisory groups from 2002 to 2007. Naomi was the secretary of the Museums Copyright Group and also a founding member of the Museums IP network. From 2015 to 2017, Naomi was a trustee of the Chartered Institute of Library and Information Professional, that is CLIP, the second largest professional organization for librarians in the world. She is a visiting lecturer at City University, University College London, and Kingston University. In November 2017, Naomi was appointed a Create Industry Fellow, and in 2018, Naomi joined the National Lottery Heritage Fund, formerly it was known as HLF, Advisors Network, as a sectorial specialist on rights management, supporting the National Lottery Heritage Fund and its funded projects. She has created the program and chaired for annual CLIP Copyright Conference since 2011. Together with Charles Oppenheim and Adrian Moore, Naomi has co-authored a new book which will be published in spring 2020. Information Law, Compliance for Librarians, Information Professionals, and Knowledge Managers. I'm really, and we all the participants really are honored to have you, Madam, today on this event. And we all welcome you on behalf of all the participants and my own behalf. From the bottom of my heart, I welcome you to this program. May I request you now to please start the session. Over to you, Madam.
Brilliant. Thank you so much, DP, and for the extremely warm welcome. I'm thrilled to be presenting today and to welcome all our viewers to the webinar, where I'll be giving an introduction to copyright for about an hour or so. And the idea is that after I've presented to you, I'll invite you to ask some questions via DP, who will then relay the questions to me, and I'll do my very best to take as many questions as time will allow. Thank you.
Sure.
Okay, so I'm just going to load up my presentation for you.
Okay, Madam, please go ahead.
Okay, lovely. DP, is that okay? You can see it okay?
Yeah, it's okay now.
Brilliant. Okay, thank you very much indeed. So let's take you through some slides. First, I'd like to tell you about the copyright of my slides. So you are very welcome to reproduce my slides for your non-commercial purposes. So that's important to always start with a copyright statement. Start as we mean to go on. And I'd also like to just give you a little gentle disclaimer saying that I'm going to give you an opinion about copyright and give you some very basic nuts and bolts. But of course, many situations are very dependent on the context. And so we would always recommend that you seek advice from a suitably legally qualified professional. So these are the things that we're going to be covering today. I'm going to give you a basic introduction to intellectual property rights. We're then going to be looking at copyright, some of the key challenges for librarians and academics, researchers. I know many of you are from those different organizations. Look at some substantive solutions that will help you move forward from today. And then finally, we'll look at some top tips. So areas that you can think about to help you on your journeys to be copyright compliant. Broadly, this is us. I just want to introduce you to the rest of my team, Patrick and Maddie, and also our website URL. If you want to download any resources from our website, you are most welcome to do so. Our team includes not only Patrick and Maddie, but we also have almost 25 of the best consultants in the UK, specialising in data protection, copyright and privacy and licenses. And you can read up all about us on our website. We've been working in the field now for over 17 years, and these are just a snapshot of some of the amazing organisations we have helped over the years, lots of museums and universities and research-based organisations, and it's our honour to have helped them along their journey to try and achieve copyright compliance and also make the best of their IP assets. So I wanted to start by setting the scene. What are the sort of key areas that we need to know about in order to place copyright within its appropriate context? I wanted to remind you about the world in which we live in today, where anyone can connect with anything, anyone else, anywhere, anytime. And this is by virtue of developments and advances in technology. I certainly remember 30 years ago when I was a student that we didn't have the technological interfaces that we have today, and simply if we needed something from the library, it meant books or journals or something called microfiche, which I kind of never really knew how to use. And today, of course, everything is electronic and electronic resources. And for those librarians of you, we're reliant on our access to e-content and e-resources. And for academics, certainly, we're looking more and more at how we can engage with our users now more than ever in an online space. And so what I wanted to remind you about is that the shifts in technology have also shifted consumer behavior and expectations about what our users and our clients and our customers expect to get from us in terms of supporting teaching and learning and resources, development and research pathways. It means that the role of the librarian and information professional has also fundamentally changed over the last 10, 20, even the last 5 years, and will continue to change. The trajectory to technological change isn't that we're at a certain point in time and we're going to stay there. Technology is only going to continue to develop in its advancements. I also wanted to remind you about recent developments and how those have changed how we do things. And I'm going to mention COVID-19 because certainly as a small company, and I know all my colleagues across library and information services and universities, we have all had to change in a very short space of time how we connect with each other and how we connect with our customers and our students and our consumers. And this has actually resulted in 3 systemic shifts. Number 1, we're using our own devices now more than ever before. Second of all, we're using different types of platforms of delivery. For example, cloud-based video conferencing technology is being used more than ever before. This year, this quarter, Zoom particularly reported its biggest sales ever. I can certainly say that we're amongst many who quickly purchased the Zoom subscription when COVID hit, so we could transfer all our services into an online space. And also, because of COVID-19 and the need to develop online resources and engage less face-to-face and more in a virtual environment, our needs for content has shifted as well. But within all this change and all these developments, whether they are more longer term or short term, our requirements for copyright compliance and our legal compliance obligations have not changed at all. I wanted to remind you as well, before we start unpicking copyright in more detail, that actually we're in a world now where content is everywhere. Everywhere we look, there's stuff. And I know a lot of this is to do with our engagement through the internet and the amount of volume, the volume of content that we have access to is extraordinary in ways that we could never have envisaged, maybe again, 10, 20, 30 years ago. And so here is a good point, once we set the scene and we've just sort of reminded ourselves about the world in which we are right now, and maybe even some of the challenges are starting to occur to you, now is a good time to remind ourselves about what we mean by copyright, particularly within the context of its broad family of intellectual property rights. So copyright is a member of the intellectual property rights family, and broadly, intellectual property rights protect fruits of the human mind. So this is anything that's resulting from unique human endeavors, original inventions and innovations, and original creations. And I use the word human very clearly and very particularly, not animal, not vegetable, not mineral, of course, nor machine. This has to be human derived. And certainly on, again, looking at a sort of a broader contextual level, there are big discussions right now about the relationship of AI, artificial intelligence, and IP. And even in the UK, we've seen certain artificial intelligence derived patents being presented at the UK's Intellectual Property Office for registration, which have been denied because they are not human derived. And this is a big issue right now being discussed at the highest levels. So watch this space. I wanted to remind you that intellectual property rights isn't just a thing for a thing's sake. It's really crucial that we have robust intellectual property rights laws to protect traded goods, and therefore intellectual property rights are fundamental to supporting trade. And indeed, countries that wish to sign some of the biggest trade agreements, certainly like India, will be required to sign some of the most important intellectual property rights agreements at the same time, and as a prerequisite for joining some of these big trade agreements. Intellectual property is named thus because, just like property, it behaves in the same way. You can buy intellectual property rights, you can sell, you can license them out, which is equivalent to renting them out, you can bequeath them. So we need to remind ourselves about how intellectual property works, what it protects in very broad brush terms, and why it's important. But that's not the only thing I want to tell you. I want to tell you more about copyright, and we'll pick up on that in more detail through today's webinar, but also mention some of the other members of the intellectual property rights family. And you'll see from the slide that some are automatic, like copyright, and also performance rights, which protects individuals who appear in audiovisual recordings. But there are others like trademarks and design rights and patents, which to get the full benefit will family, a blend of automatically protected rights, which arguably are not as powerful as the ones that you register. In other words, the more you register intellectual property rights, the greater the cost, because registration takes time and it costs money and resource and capacity, but the greater the benefit. So the more valuable your product or your invention is, the more you would look to registering your intellectual property rights. But that's a whole nother webinar I could run for you. We're focusing today on copyright. So to remind you, copyright, again, in broad brush terms, is an automatic right that protects creative works. And just a little reminder here, please don't forget other legal issues like privacy. Certainly in the EU and in the UK, we have had a big change in our privacy laws through GDPR, which many of you may have heard of. So often in our worlds, we have an interconnectivity between copyright and other legal issues. So this is just a little reminder about that. So why is IP important other than what we said already? Well, we need to be aware of IP because we need to respect other people's intellectual property rights. And there are penalties of all shapes and sizes if we don't. But also, it's a combination because not only do we need to remind ourselves about other people's intellectual property rights, not infringing their rights, but also we will also have organizational assets for which IP will be relevant to us in terms of our ability to make money from our derived IP. So IP can underpin our business models. It can support our strategic objectives of sustainability or resilience or standing on our own 2 feet. And what we're seeing as well now, and this is very interesting in the COVID crisis, some organizations are having to identify and value their IP assets because they need to find something to base financial leverage on if they're looking, for example, for company loans. So this has become an even more important issue that we understand what IP we have, how much it's worth, how it can support our business models, but also how much value it has to support perhaps other types of activities we need to be looking at today. So I'm going to begin our journey on copyright. So you've had a broad introduction to the setting the scene and into other types of intellectual property rights. And now we're going to be looking at copyright. And I wanted to let you know that far from it being something that's very new, copyright is extremely old. In the UK, we have some of the oldest derived copyright laws. And in the UK, we have the Statute of Anne as being the first significant copyright law in the world, going back to the year 1709. So a significant development. And this was simply because publishers who had benefited very much from the Industrial Revolution in the UK back in the 15th century and the development of the printing presses wanted to have harmonized laws that protected their investment, i.e. the published book, for example, the St. John's Bible, which needed protecting. So copyright laws in the UK derived from publishers who wanted to protect their business models. And this is actually a real photograph of the Statute of Anne, which I went to see at the Parliamentary Archives, and many thanks to the Parliamentary Archives in the UK for being able to show me this. And also, I was very privileged to see the 1911 Copyright Act, the 1956 Copyright Act, and the 1988 Copyright Act side by side. And for a copyright geek like me, it was very, very happy days that I could see all of the original documents. So when we think about copyright protecting creative works, we need to remind ourselves as well that we are all creators, and this particular image is thanks to Birmingham Museums Trust, who have made this image and many, many other images available for reuse with no restrictions at all. So a very good place to find content you can use for free. But whilst we are all creators, and when we think about being creators, we also need to remind ourselves that we are also publishers through social media interfaces. So today, more than ever before, it's easy for us to take our own photographs of things we see around us, or paintings or drawings, and then publish them instantaneously. So whilst we are all creators, we also are users of other people's copyright work. So our feet stand on both camps. We're both users of other people's stuff and creators of our own copyright works. So what does copyright mean exactly to us? Well, it means that if we're a creator of a work, a painting or a drawing, even a text, something like that, we have the exclusive right, so we have the only right to allow other people to reproduce what we've made. It's our right, it's our benefit. I guess you can see it as a reward for coming up with something that's original, that no one else has done before. It then means that if we want to use something that someone else has done and they're the copyright holder, we have to respect that they too have those exclusive rights. So there's a lot here about mutual respect. Now, to give you a little bit more information, and I know most of you are joining us today from India, I have given you a link to the Copyright Office in India, and I've also referenced your copyright legislation. So to remind you, if you know already, or for those of you who haven't been aware of it, there are lots of different acts that India has. The 1957 Act, and it's been amended 5 times since then. The latest iteration was in 2012. So please read up about this afterwards so you can find out more about Indian copyright law in detail. Today I'm sticking to general principles, but I will be referencing other nuances relating to Indian copyright law as we go through our webinar. So what does copyright protect? We've sort of starting to understand some basic key principles. We need to remind ourselves that copyright doesn't protect ideas. So if you have an idea to do something in your head, to paint that painting you've always painted, to make that sculpture you've always wanted to make, or to compose that piece of music you've always wanted to compose, there's no copyright in the idea. It's when that idea becomes tangible. You can see it or hear it or touch it. And it can be digital and it can be print. It doesn't matter. It needs to exist. And there's a really lovely logic there, I've always thought, which is that it's very hard to prove that you're the copyright holder of something if you haven't made it. But certainly if you've made it, if you created it, then you can demonstrate that it's protected by copyright. And I was mindful that when I looked at the Indian Copyright Office website in preparation for today's presentation, there is a process you can go to register your copyright with them, because that can be very useful if there's an infringement. And so it might be worth considering, if you are a creator of something that's original, okay, that's new, that's never been done before, you might want to look at registering it if you're worried that it could be infringed, or if it's got more value for you, maybe that you want to make money from it, or it's got very sort of high reputational value for you. And you can go and have a look at the link I gave you in the previous slide to connect with the Indian Copyright Office. Now, I want to talk, before we go into any more detail, about duration of copyright and some of the specific categories of works that copyright does protect, and look at the issue of ownership. And I find in my career, and I've worked with lots and lots of different organizations and museums and libraries and archives, that often colleagues that I work with, and even visitors, whether it's to the website or coming to the premises, often get confused about the difference between something they may own and the ownership of rights. And so the little example I wanted to give you was, in theory, if I were to write my cousin a letter and my cousin gives the letter to his wife, I wanted just to sort of give you a moment to have a ponder over who might own the copyright in that letter, based on what we've talked about so far. Is it me? Is it my cousin? Or is it my cousin's wife? Okay. And I find this little scenario extremely useful for unpicking the differences between ownership of rights and ownership of content, because indeed in this particular scenario, I would be the copyright holder in the letter because I wrote it. I'm the one that benefits because I put the words down. They're my words. And that's what we need to remind ourselves about copyright. You can own something, but it doesn't mean you own the rights. And if you don't own the rights, it doesn't give you the ability to freely reuse that item. So let's break this down a bit. I said that I own the rights. My cousin would be the recipient of the letter, that's fine. And then my cousin gives the letter to his wife. Well, my cousin's wife would then be the owner of that particular letter, but that wouldn't stop me in any situation from owning the rights and being the one that can control whether that letter can be copied or not. A little bit about duration for you. So how long does copyright last for? It actually lasts for a very long time, much longer than a lot of people think. The duration of copyright in India is the lifetime of the creator plus a further 60 years after they've died. Okay, so you can have items in copyright for hundreds of years if someone lives for a very long time. In the UK, we have lifetime of the creator plus 70 years, and then there are other countries that have lifetime plus 50 years. But 50 years, lifetime plus 50 years is always the standard for most countries in the world, by virtue of the fact that pretty much all countries in the world, apart from really just a handful, have signed up to major conventions, and in particular something called the Berne Convention, which actually, as it turns out, is a requirement to sign up to before countries are allowed to sign some of the significant trade agreements that I mentioned before. So types of works protected by copyright. Again, looking at your legislation in India and looking across other countries' legislations, there is a certain similarity between the types of categories of works protected by copyright. These are the main types of works that would normally be protected. Artistic works, which are things like photographs and drawings and paintings and sculptures. Musical works and musical compositions. Films, audiovisual, that could be documentary films, it could be commercial films, amateur films, it doesn't matter. The point being that they need to be original, that the same thing hasn't been done before. Because as you remember me saying, copyright is like a reward for coming up with something that no one else has done. Literary works, that's text-based, that could be published or unpublished, letters and journals. I work with the Imperial War Museums, and one of the sites is the Churchill War Cabinet Rooms, and we have there some of the letters written by Winston Churchill, which of course would be his family's copyright. We have other categories of works protected by copyright. Dramatic works, that might be a screenplay, or that could even be instructions for actors who are enacting certain emotions on screen. Typographic arrangements, which is the layout. That could be the layout of a book or a document or even a website. Sound recordings, recordings of people talking, oral history recordings, recordings of music or sound effects. And finally, broadcasts. So Under Indian copyright law, there are variations of this, but there are an awful lot of similarities as well. And it's worth checking your own country's legislation to find out specifically what's protected under your own copyright laws. So a little refresher before we move on with the presentation today, to remind you about the difference between the owner of the content and the owner of the rights, and also to understand what it means to have this exclusive right as the copyright holder. And it means if you're the copyright holder, you have the exclusive right to control other people copying your work or broadcasting or performing it, renting it out or licensing it is a term we use, and we'll come back to that term as we go through our webinar, making it available to the public and communicating it to the public. So to be clear here, putting something online without permission from the rights holder, from the copyright holder, would be a restricted act, and you would need to ask permission in order to do that, and that's communication to the public. Now, counterbalanced with these exclusive rights, and in Indian law, you have a combination of both fair dealing and fair use exceptions, which I'll be referring to later. And in other countries that are represented by people watching this presentation today, you will also have either some kind of fair dealing exceptions to copyright or a fair use regime, or indeed like India, some kind of hybrid. And these are the balances built into your legislation or legislative framework that provide, on the one hand, the exclusive benefits to rights holders versus certain limited types of uses of those works that are seen to support the public interest, the greater good, support education and culture and research. And every country will have something like that, some more than less. As DP kindly read out at the beginning, in the UK we had some copyright law changes in 2014, which actually saw the UK move from being, I'd say, behind other countries in its exceptions to copyright to being ahead, to such a degree that some new copyright legislation coming from Europe is very closely based on what we have in the UK. Now, with all of this, we're not just talking necessarily about one layer of copyright, we can be talking about multiple layers. So if you look at the central screen in front of you, you can see that all the different categories of works are listed out, but we can have also other types of intellectual property rights and indeed other types of legal issues associated with maybe content we want to reproduce or content we want to put online. Good examples are photographs of people, where you might have copyright in a photograph and you may have rights associated with the individuals appearing in those photographs. Anyone who's watching us from the EU and is subject to GDPR would need to be mindful that living identifiable individuals would also be covered under data protection laws. So some issues, and this is perhaps why many of us lack confidence in copyright. On a very basic level, the principles of copyright make sense and they're very sound, but how it applies then in the technological environment in which we operate becomes more complicated, and how it applies on an organization by organization basis, how it applies to the really sometimes very unique items that we wish to reproduce or create, then means that we have other layers of complexity that we need to understand. So what I've tried to do is to break these down into issues, and then later on in my presentation to give you some of the solutions to try and understand and to create a pathway for you moving forward. So the first issue I wanted to bring to your attention was the issue of multiplicity, which is that, as I said and as I demonstrated, we often have different layers of IP and other types of rights happening, and the more layers of rights, the more rights holders that might involve, the more time it's going to take you to understand and unpick those rights and perhaps deal with the rights, and the greater the cost. So the more complex the media, and we have a lot of complicated digital media, complex, comprised of different elements that we may wish to reproduce that other people have created, the more time it's going to take us to clear the rights. Another aspect of multiplicity that we have, which is actually more of a sort of a function of the nature of the organizations perhaps represented today, watching today's YouTube broadcast, is that in any one organization, there's going to be a whole range of different types of activities that are taking place regarding content, and therefore will touch upon copyright issues. That could be commissioning of content, creation of new content, publishing, and sharing. And then if you think about all the different departments you might have, a marketing department and a research department, a comms department, an exhibition department, a teaching department, a technology enhanced teaching department, there's much content flowing around your organization with many different copyright issues. And how we store information about both the content and the rights issues associated with it, indeed whether we do at all, can be variable, but many of us are using multiple types of systems to record that information. So far from there being one system that records all the content we're commissioning and creating and acquiring that might be deposited with you or on loan to you or you're lending out or whatever it is, and the information associated with it, we often keep that information in different places, and some people keep that information on their email systems and on their C drives. Unless you're massively lucky and have a digital asset management system where you can have everything stored in one place, most of it is scattered around the place, makes it much harder to track. And that's also linked to the fact that many organizations have different types of relationships with people involved. It could be staff and contractors and volunteers and different people involved in content creation and acquisition and commissioning and use, etc. I wanted to bring a second issue to your attention, which is the connectivity, and simply to say that much in our experience and with many of the organizations we work with, staff are actually pretty good at dealing with copyright pretty well. And they hold fantastic amounts of information in their minds, but we're not so good as a sector. And I think there's a growing movement towards this. And certainly in the UK, we have sort of specific groups for knowledge managers and information professionals to try and address this. But actually connecting staff and their knowledge to the content itself. So trying to deal with the big issue of knowledge management. And when it comes to copyright, and if someone has maybe negotiated a very good copyright license or very good deal for the organization, finding a way to encourage them to document what they have done rather than keep that information in their heads. And again, there are challenges we have as organizations with sort of linked to the issue of multiplicity, multiple types of engagement with content and multiple people using multiple systems, which is just connecting the content with the process to clear the rights, following formal processes. We've, over the years, worked with many different organizations and museums and libraries and archives to help them develop formal processes so staff know what to do when they're engaging with content, no matter what, when to clear rights, what rights to record, what processes they should be following, what should they do if they can't find the rights holders. And that's fundamental. And it means that I think our very views as copyright being this other compliance issue needs to be brought back into whenever we think about content, thinking hand in hand about the relationship between the content and the copyright, the rights to use it, who owns what rights. And this information can then be connected to the content. And finally, I wanted just to pick up on an issue of reliability, which links very substantially to the first two issues that I've spoken about, which is that those organizations we've worked with that have had systems and databases to record the copyright associated with a piece of content, use variable structures to record that information. They might have a sort of a free text where they record that information. I'm a great believer in sort of structuring fields on a database to record information so that that information is then more easily searchable and retrievable. Many organizations we work with don't record the information at all, or indeed it's out of date. So that reliability, even if there is a rights information, can be variable. So again, taking a bigger view, because I want to home in on some of the sort of more specific issues relating to copyright and how you can move forward and what you can do next. I wanted to remind you graphically about sort of the situation we're in, and this is across the world, which is that the speed and sophistication of technological change is so much faster than the speed and adequacy of legislative change, and particularly copyright laws. So there's so much more that we can do with technology than the law allows us to do. And to show you what the responses are, and then how we deal with this as librarians, information professionals, academics, and whatever your role is, whoever you are that's joining us today. So responses to the difference, the discrepancy between, on the one hand, the speed of technological change versus the adequacy of, say, copyright laws specifically, are that when there's more that you can do with technology than the law allows you to do, the first thing you probably would do would be to seek permission or seek a license. So you'd go to the person whose stuff you wanted to use in an innovative way, and you say, can I have permission, please, to use the stuff for which you are the rights holders or you're representing the rights holders? That would be the first response. The second response, typically, that we see is using or relying on an exception to copyright. And I've already mentioned that in India, we have a hybrid of fair use and fair dealing. So something like quotation or educational uses, and I've got a slide in a few moments where we can look at those in more detail. Some of us are faced with thinking about risk management. I've done a lot of work in the UK looking at something called Orphan Works. And these are works in copyright where you can't trace the rights holders or they're unknown, and giving advice and support to many national museums, for example, about how they can make those works available online, and thinking about the role of risk management. Another, and we'll talk more about that in a bit, another response to the discrepancy between, on the one hand, the speed and sophistication of technological change versus what the laws allow us to do, is some people just don't do anything. And there is a lot of risk aversion because there's fear. I think that there's a lot of a lacking of confidence and also skills, which is obviously the two are interconnected. And we have done a lot of work over the last 20 years to try and redress some of that and help staff become more confident in understanding what their requirements are and to give them sort of help resources to move them forward. And then finally, I think the response that we see are sort of not as much, fortunately, is breaking the law. That, you know, the other response to the frustration, perhaps, that whether it's academics or researchers or our colleagues in the cultural heritage feel, can be perhaps breaking the law. As I said, it's not as perhaps more as not as widespread as not using something at all, but it is a noted response. So how does that make us feel? What are some of the risks associated with particularly breaking the law? What would that mean? What would that result in? We can sort of perceive them as operational risks. We can see them as a result of us giving the wrong advice. We can see them resulting from enabling more copying than we should, or using things without permission. And also the people that we support, maybe that if we break the law, then it might mean that they end up copying more than they should, or using items in ways that they shouldn't, or perhaps viewing or downloading the wrong type of material. And what's the impact of this? What might happen if it goes wrong? Well, under Indian copyright law, infringing copyright can be a criminal offence, as it can be under UK copyright law. And I'm sure when you check any more country-specific legislation, that will also be repeated. Infringing copyright can lead to financial penalties, so paying damages to rights holders. These are the things that don't get to court. These are things that I often hear about, which is where clients of ours might have used something mistakenly without getting permission, or maybe they thought they could use it, and then being asked by rights holders to pay, and to pay not just the license fee, but to pay an additional fee. So financial penalties, money that you perhaps hadn't intended to spend, you'll have to find. Many organisations are concerned if they break the law that there will be bad reputational impact, that it will float a bad light over what they're doing. There may be operational disruption, and that could result in resources that may have taken some time to put together having to come down, or disrupting certain teaching or research-based practices because what you're using you're not allowed to do. It takes time to make things better. So even if it's just an apology to the rights holder is enough, it still requires someone's time and energy to apologise in the right way. There are concerns about the impact of infringing copyright, that people who would normally use our services won't use this again, and then you can see that sort of gets worse and worse, so possible disciplinary proceedings or job losses, and indeed criminal proceedings if there has been a substantive and sustained infringement of copyright with a large amount of material, or for example, if any technical protection measures used to protect the work from being used have been broken. Those sorts of things can result in criminal proceedings. So the impact can be unpleasant at best and very worrisome at worst for an infringement of copyright. So what are some of the solutions that I can suggest to you to make your lives easier, to give you some kind of pathway to remaining on the right side of the law, not worrying so much about copyright, and getting moving ahead with the projects and activities that you want to do in a legally compliant way? Well, I said that I'd be looking more at fair dealing and fair use under Indian copyright law. And India has, as I said, a hybrid approach where there are certain types of uses that can be done under fair dealing for private or personal use. This would include research, certain education activities, criticism and review, or reporting current events, so sort of news-related activities, and giving a lecture in public. It doesn't mean that anything can happen. It doesn't mean that every activity online is okay, or indeed any activity online is okay. It doesn't mean that someone else's copyright work can be copied and sold, or posters made or placed online. So there are real restrictions, but this gives wiggle room. It means for certain worthy activities, there are some defences to copyright law, and this is nicely balanced by, as I said, the hybrid component, which is fair use, based very closely on a US model. So I'd like you to remember the exceptions to copyright, because we're covering a lot in today's webinar. I would strongly recommend that for those of you based in India, if you would like to follow the link that I provided here, and those of you based in other countries, if you can check your own country's copyright laws to look at the exceptions to copyright. Certainly in the UK, with our changes to copyright law in 2014, one of the really useful exceptions to copyright is a quotation exception, where you can use an extract of someone else's copyright work for illustrating a point. You can only really use as much as you need, but it's an extremely useful exception, and many other countries in the world will have a similar quotation exception, but you need to check. And I'd also like to just stress the point here that exceptions are based on where the user is geographically based. So if you're based in India, you'll be subject to the Indian legislative regime. If you're based in the UK, you'll be based on, your understanding of copyright laws need to be based on the UK copyright law in place, and wherever else you are as well. So please check your own country's copyright laws. So solution number 2, how can we find content that it is okay to use? And one of the biggest recommendations I can make is to find content that's licensed out under something called a Creative Commons license. Now, Creative Commons was established well over a decade ago in the US by Professor Lawrence Lessig. He set it up as a not-for-profit, and what he wanted to do was to try and find a solution for people like us, users of other people's copyright works, and also creators who wanted to share their copyright works. So he established the Creative Commons in order to set up and create 7 different licenses. These licenses range in different permissions, and the 7 license types enable a copyright holder, someone who owns the copyright or has permission from the copyright holder, to attach a license of a particular flavor to their copyright created work. And that means that anyone else who comes across that content with the little badge or the license attached to it knows how they can use the work without having to go back and ask for permission, because permission is already granted. And these range from allowing somebody like museums in Birmingham have done to do anything they want with the work, to more restrictive Creative Commons licenses, which only allow use for non-commercial purposes and also might restrict the work from being edited or changed. So it depends on what the license type is. Now, if you are using a work within the license terms, that's fine. You don't need to go and get permission. You need to honor the terms, and the licenses are available in very easy to understand formats. But if you want to do something more with the work, you would need to go and get extra permissions from the rights holders. The little caveat about Creative Commons licenses is simply to just be aware that although most of the content that you'll find under Creative Commons licenses is probably okay to use, if something feels that it's too good to be true, it probably is. And what you would probably need to do is a few further checks to make sure that the person who's put the license on that piece of content actually has the authorization to do that, or the authority to do so. You can do some simple image reverse searches in order to check that out, but it's about reassuring yourself, because if you then subsequently use content licensed under a Creative Commons license and the person who's put that license on it doesn't have the rights, you yourselves will be infringing rights. Now, a way around this, beyond what I've suggested already, is go to recommended sources of content. And I've given you some links here. These are 3 of my favorites. One is Art UK. It's a UK-based charity which has worked with many, many museums and collections across the UK to create this fantastic sort of repository of content, and has to date over 250,000 images on its website, many of which can be used under a Creative Commons license. Now, it's been my honour to have worked with Art UK from the beginning of the project, and I work with them on a license picker. So this is a functionality of their website where you can go online, look through their website, and then if you have a particular Creative Commons license type of content you're looking for, indeed, or just want to see all the Creative Commons license content they have on their website, you can use the license picker in order to help you do so. So that's got some fantastic stuff on there that you can use and is an authoritative source of content. So you don't need to worry that you can use that content or not, only within the terms of the license, of course. My second recommended source of content is Wellcome Collection Images, and they have hundreds and hundreds of thousands of different images available under 2 different types of Creative Commons licenses. One just requires you to credit the source and credit any rights holders, and the second requires the crediting, but also restricts use to non-commercial uses. But certainly those of you who are working, developing online resources or supporting your colleagues and staff creating online resources, it's a fantastic source of content. And then my final recommended source is Europeana, which is a European Commission funded initiative for European cultural heritage organisations in order to provide a one-point access to all their content, much of which is available under a Creative Commons licence. So 3 fantastic sources of content for you to use, which should give you confidence in understanding that you're compliant with copyright, and as long as you stay within the licence terms, reduce the resource and issues that you will have to think about in terms of clearing rights. Okay, 3 more suggestions from me in terms of finding content it's okay to use. Linking to stuff, okay? Be clear and be sure that what you're linking to, you can legitimately link to it, so that if it's on a website or on YouTube, that the person who's put it up there had the rights to put it up there in the first place, number 1. Number 2, that it's still live. And third of all, that if you're getting it from a website, you're linking to a website, there's nothing in the terms and conditions of the website that preclude you from linking to it. And then the 4th obvious thing is if something's behind a paywall and you want to link to it, don't break the paywall in order to get to that content, because you're going to get into lots of trouble for that. But if you don't have to go via a paywall, it's publicly available, there's nothing to stop you from not linking to it. Certainly that gives you more opportunity. And if you really want to make sure, please contact the owner of the website and you can just double check that through. 3rd point from me is create your own stuff, and this is all about what copyright was all about at the beginning. It was all about trying to create a framework for business, protect creators, but also create an incentive for us and you and me to create our own stuff. So if you can't use something, if you can't find it and there's something you're looking for, go out and take your camera and take your own photograph and create your own copyright protected photograph. And finally, you can always think about commissioning someone else to create content for you. But remember, if you do commission someone else to create content for you, unless they are an employee, a member of staff, they will own the rights in what they've done for you. So you must make sure you have a contract with them that clearly stipulates who owns what rights and what you can both do with the content that's created. You can't ignore that. My 3rd solution, getting permission. So if you like, think about this sequentially. Look at getting an exception first, or trying to find content you can use. Then think about if none of those apply and you really want to use something and you know you can't, these are some tips for getting permission. So give yourselves time. If you've got to run around trying to find the rights holders, sometimes they don't answer very quickly. Sometimes you might have tight deadlines. The earlier you start the process, the easier it is for you. Build copyright compliance and tracing rights holders and licensing into any of your resources, extra capacity, your budget planning, your project initiation documents. Be clear about what you want to use and how, because if you do find the rights holders and you're uncertain, that's also going to mean that you might end up negotiating a license that doesn't quite cover what you really need. So be clear about this. Again, think about this at the beginning. If you do come across content and you can find the rights holder, or maybe it's available already under a license, or you go to a big picture library like the Bridgman Art Library or Getty, read their licenses carefully. Make sure that you can comply. Make sure you understand what you can do and also what you can't. Check the durations of the license, check the territories, select and make sure that you have the right users noted and the right activities, because if your license doesn't cover all your purposes for what you really need, again, you run the risk of infringing or spending money on a license that doesn't quite cover all your uses. I'm a great believer and a great fan in negotiation. So give yourselves time to do that. If you are asked for a fee from the rights holder, from someone issuing a license, and you haven't got the money, tell them what your budget is, push back. And you can push back quite hard and you can negotiate quite hard, that's okay. Try and think about if there are any deals that you can do. Maybe if you've got more than one piece of content where you can get a better deal for more than one piece of content, or maybe find out if there's someone in your organization who also wants to use that content. And then you can maybe get a really good bargain for that. And clearly, if you're not happy about it, and even in the middle of negotiation, walk away, be brave. And this is, again, goes back to the point of giving yourselves enough time to do this. There's a lovely story that I tell a lot about one of the colleagues that I work with at one of the national museums that I support in the UK, who was asked for, it's about £18,000 worth of licensing fees to use 3 small pieces of film that were 30 seconds each. And the colleague that I work with on this absolutely needed these 3 pieces of content. They came from the same piece of footage. And she said to me, look, Naomi, she said, what can I do? How can I get around this? I said, look, negotiate, go in hard. And she was so successful, and she really listened to me. She really thought hard about how she could bring the price down, that she brought the price down from £17,000 to £500 for all 3 pieces of content, because she was brave and confident and knowing how much money the organisation had. So there are some sort of good news stories in here for sort of being robust in negotiation. And then if you are successful in getting the permission that you need, make sure that you record what the license says, when it expires, what it covers, and tell everybody who can benefit from it. The number of times we've seen really successful license negotiations, but staff and contractors don't know what those license terms are, and it's a real shame. So it's about communicating it and raising awareness. I wanted also to talk about Orphan Works, because I did mention these, and I just wanted to sort of pick up on issues that I've managed to work with for the organisations we've represented here in the UK, and to think about Orphan Works. Not all Orphan Works are the same. Older Orphan Works arguably are easier to use than more contemporary ones. Depending upon the type of orphan work, it might represent either greater or less risk. So think about each item, and also the context of use matters. And we've done lots of work with UK-based cultural heritage organisations on risk management, and that means documenting efforts to try and trace rights holders, having clear processes, recording all the processes that are followed, having checklists, having what we call notice and takedown policy and procedures. So having notes on your website if someone comes forward and isn't happy, so you can deal with it quickly. And this is about risk mitigation, so risk management and understanding the nature of the work within the context of how it was created, for what purpose, the nature of the possible author, and your context of use, and your kind of subsequent pathway forward is directly proportionate to how you can make it better if it goes wrong. And I like to use the term a lot with everything that we do, reasonableness. And you remember I said at the beginning of this presentation that you will be both a copyright holder and also a copyright user. Well, reasonableness and using someone else's copyright work, particularly if it's an orphan work, I would say should be a gut feeling, and we should be asking ourselves, okay, well, if that were my work, if I were the copyright holder, how would I feel? Would that be reasonable? And that often gives us, I think, a really good sense. It's a judgment call, right? It's about trying to understand how we would feel if it were our work, as a way of understanding, would it be reasonable for us to use such a work? The other 2 points I would raise about dealing with orphan works are document decisions, keep a record, and finally, making sure that there is a high level of awareness in your organisation about them and what you should do if you encounter such copyright works where you can't trace the rights holders or the rights holders are unknown. So what are my top tips? There's a lot here, right? I wanted to break it down into 7 key tips for you to take away, for you to digest and think about as a pathway for moving forward, taking away some of the fear about copyright and giving you some practical steps to remain compliant with the law. So number 1, think about how you can use and provide access to others and links to content that can be used, a bit like what I did for you, okay? It's not just about saying to people, you can't do this or you can't do that. I'm a great believer in supporting colleagues, students and staff by saying, okay, this is what the principles are and these are things you can do, okay? So number 1 is all about that. Second of all, think about the exceptions to copyright and fair use. Depending upon the jurisdiction in which you're based, you will definitely have them, look them up, read about them, think about using them, and think about using them more. Now, some are a lot about using the sort of reasonable test and what we call risk management. They're not always clear cut, but ask yourselves, under the exceptions to copyright, if I wanted to use something in this way, and if that were me, then it was my work, how would I feel about that? Number 3 top tips. Make sure you do seek permission if you need it. So if you want to exceed the terms of the license, or you find something and you don't know whether you can use it or not, or you definitely know you can't use it because someone represents the rights holders or there is a licensing body, make sure you do get the appropriate permissions and give yourselves, number 4, enough time to negotiate. And sometimes we might need to walk away or find something else. Number 5, build into your organisational procedures a risk management procedure for dealing with orphan works, because they are a reality. In 2009, I carried out, it was probably one of the world's first proper surveys looking at the impact and extent of orphan works, and this was in the UK. And at that point in 2009, we extrapolated that there were about 50 million orphan works in the cultural heritage sector. I don't believe that figure is realistic anymore at all. I think that's a mere drop in the ocean. I think there are hundreds and hundreds of millions of orphan works across the world's cultural heritage organisations, but even on the internet, because there are no regulations for people putting down on an image or associating with an image who the rights holder is and what can be done with the work. So you've got these amazing images floating around the internet that have no information. And far from them being free to be used, it's the opposite. If there's nothing on an image you find on the internet, the default is you can't use it, because if you remember, I said at the beginning of this presentation, copyright protection is automatic. It doesn't require registration. Therefore, finding an image without a credit line or information about reuse means the default is you can't use it. And this links to the potential of getting more and more and more orphan works. My top tip, number 6, there's lots here and there's lots to digest, but keeping your training of your colleagues and people you work with up to date is important, not just about understanding your requirements for legal compliance of other people's copyright works, but also so you can make the most of your copyright works, whether it's research papers, making sure you understand the relationship between yourself and maybe publishers, if you're a published researcher, the teaching resources that you create. Some of you may even have opportunities to make money from your copyright as well, but be aware about what it is, keep awareness and training high. And my 7th top tip is, again, if we want people to be compliant, we want people to understand what their obligations are, whether it's people we work with or have any type of interface, however remote it might be, virtual visitors to our websites, users of our online resources, our students, colleagues from different organisations that we may be working in partnership with, our clients, our visitors when we get back to more face-to-face engagement. Tell them what is okay. Be clear with them about what you expect from them. Don't expect that they know without you telling them. So be clear to them and articulate clearly what they can and what they can't do. So there's lots to learn here. There's more that we can do for you. We've got a full training program that provides lots of information about copyright and data privacy and IP, done in a very similar way. I'm the main presenter, but we have guests presented as well. You can engage with us anywhere in the world. That's one of the beauties now of us providing training online. And you will also get, as you have done today from me, really important practical next steps, very much geared to cultural heritage organisations, education establishments, libraries and archives. If you want to buy the book, there's always a book to buy. DP mentioned, thank you very much, DP. My book's actually going to be published at the end of this month. It was a little bit delayed because of COVID, but we're delighted that our publisher, Facet Publishing, which is the UK's primary publisher for library and information professionals, is now back fully operating, and we will be seeing copies. I think it's on the 26th of June. I've given you a link here. You can find out more. It's actually a book all about our company, the Naomi Associates methodology for dealing with legal compliance. So it's something that's not out there at all, and looks both at looks at copyright, data protection, and for those of you where it's relevant, freedom of information. But because, you know, we do so much work as a company in supporting our community, there's lots of stuff you can download from the Naomi website. If you go to the resources page, there's loads of stuff available under a Creative Commons license. And I'm very proud of that, that we actually not just provide access to authoritative resources that we've written, checklists and templates and fact sheets, but we've provided them under a license for you to be able to reuse them yourselves. And we ask that you credit us, and we really try and enable that reuse across our sector. So I wanted to thank you. It's about an hour since I've been talking. I wanted to thank you, DP, for inviting me to talk to you today. I wanted to thank all of you for joining me along the journey of copyright. It's the start of the journey, it's an introduction, but I hope that you found it informative and interesting and helpful, and has more than anything given you some things to think about to move you forward in developing your own confidence and the skills both of yourselves and the colleagues that you work with. So DP, if I could pass over to you and invite any of you to ask questions or to address any questions you may have asked as I've been talking. Thank you so much.
Thank you very much, madam, for a very elaborative session. I think I request you to please stop sharing the screen so we can interact now. I think you have touched upon every area which is related to copyright and with a special reference to India, and especially you have given and thrown lights on different aspects, that what is the fair use and what are the things we need to check before we use any content, and we should be sure whether it is ready to use or not. And that is really very important for especially the researcher or whoever is original author of the content. Because it creates a lot of problem if you do not follow the copyright law. And thank you very much, madam. You have given a very elaborative information. You have discussed in detail. So first of all, on behalf of all the participants and my own behalf, please accept my sincere thanks and gratitude for your time and also for your talk. Now, may I just request all the participants to please share the, means you can ask the question, the session is open now. And one question, with your kind permission, shall I ask the question now, madam?
Yes, please.
Yeah, so one question is from Mr. Virendra Kumar Pandey. The question is that, is sharing taken picture by mobile or e-book, e-newspaper downloaded by the website is legal? The first question. Shall I repeat, madam?
Yes, please.
Yeah, this question is that, is sharing picture by mobile or ebook or e-newsletter which is downloaded from the website is legal or not?
Is it legal to share a picture?
Yeah, if he or she has taken the picture through mobile from ebook or website or newspaper or downloaded from the website. So whether it is legal or not.
Okay, the answer is it depends on several things, and actually that's a lot of the answer to copyright and some of the complexity. It depends on what that photograph is going to be used for. So most countries in the world will have a proviso that allows for personal use or private study. So if that photograph is taken for private study, so that means that person who's taken the photograph just looks at it for their own research-based purposes, they don't give it to anyone else, they don't reshare it, they don't publish it, then under most legislative frameworks, and I believe under Indian copyright law, that would be okay. But if anything else is done with that photograph, if it's republished, if it's posted up on a social media website, then there may be problems, particularly if the terms and conditions of the e-resource that have been accessed say you can't do it. So the answer is it depends on the use, and also actually depends on quantity, because normally the use is a very small amount for personal use as well.
Okay, Madam, the second question from Mr. Birendra Kumar Pandey. How to check licensed and what's the process to take the license? If I share and document without checking, what will happen?
Okay, so how to check a license. So if there is, it depends if there is a license. The easiest thing to remember for the person who asked me the question is, remember when I spoke about what you're allowed to do and what you're not allowed to do. So if you assume that you can't do it, unless there is something that says you can, assume you can't. And if you're going to share someone else's article without their permission, and there isn't anything to say you can, then you need to be aware that you have, there's probably going to be, there may be a problem, but what could happen, well, it depends if they find out. If they do find out, they may not be very happy. It might cause tensions between you and them. If the article is published by a publisher, the publisher may not be happy. So I guess an example might be if you take an article by somebody and you post it up on another website like ResearchGate. Okay, if you do that, and you haven't got permission from either the author and or their publisher, and indeed it may even be your own article that's published that you want to put on ResearchGate, there will be a number of problems. Number one, you may be in breach of your own publisher's agreement with you in publishing something for you. And second of all, you may be in breach of the ResearchGate terms and conditions, because they will only want you to post stuff that you have permission to post. And then there can be impact. So if the researcher finds out or the publisher finds out, they may not be happy, they may fine you, and there may be sort of reputational issues as a result. So the answer is, for the second time today, it depends on what you're doing and whose stuff you're using, but the best kind of summary of my answer is be aware of the things you can't do, the restricted acts that I went through on this presentation, and assume you can't do it unless there is actually something that says you can. Okay.
Thank you, madam. Can I ask some more questions, because a few more questions are there. Another question is from Sanmati Jitendra Jain, Mr. Jain. Can I scan course material and put them on my library website for students to read? Will it be legal? Can I scan the course material which is available in the physical format? So yeah, he's asking whether he can scan it and put it on the website for reading purpose for the students or not, for educational purpose.
Okay, thank you very much for the question. So in the UK, most of our, say, higher education establishments, our universities and colleges, in fact, all of them will have a license with a collecting society called the Copyright Licensing Agency, which represents publishers. And they've negotiated a license which they pay money for every year in order to do things like that. So I know that in the UK, that's what they can do, but because they've negotiated a license and they've paid money, quite a lot of money, each university every year to do that, and then to also use, say, scans for courses, to enhance courses and to build online courses contained within a virtual learning environment, etc. I don't know what you have in place in India, but I would suggest that before I give you any more of an answer, it's worth checking to see if you have an equivalent collecting society or big agency that represents publishers, and whether your own organization has such a license in place. And if you don't have a license in place, to think about whether it might be worthwhile for you to get such a license to enable you to make those scans and to use digital copies and scans to support your internal activities.
Okay, thank you very much, madam.
Pleasure.
Another question is from Mr. Randhir Kumar. He's asking, what is the difference between copyright creation and copyright registration? I think
Okay, so very good question. Thank you. So copyright arises automatically, and this is pretty much for every country in the world. If you create something that's original, unique, it's created by somebody, like they call it a natural person, it's a human being, and it's one of those categories of works. It could be artistic, literary, it's a type of work that has the potential to be protected by copyright. Copyright arises automatically and doesn't require registration. The US has a slightly different system, so just to sort of be mindful of that, but generally elsewhere, it's pretty much straightforward, it's automatic. Now in India, your Copyright Office, because I researched into this, does provide a step-by-step registration of copyright, but it's not a requirement of copyright protection. The registration process you would go through for copyright would be if you want to be able to demonstrate that you are the copyright holder, maybe because you worry that someone might infringe your rights, or what you've created you're going to take to market, it's got high commercial value for you, it's really important for you, you want to just be really, really sure that you can demonstrate it's yours. That's what the registration process is in India. So it's not a requirement, it's an option, but you need to think about, I guess, the risks of someone infringing your copyright, and then the benefits and costs associated with an extra layer of registration. I hope that helps to clarify that.
Thank you, madam. Last question, if you allow. And that is from Mr. Mohan. His question is that downloading e-newspaper is legal or illegal?
It depends. Okay, I think
because,
that's
yeah.
It depends. So generally, e-newspapers, the business model. Okay, so think about it. If you were an e-newspaper publisher, you need to make money somehow, right? Because you need to pay your staff to create the articles. Normally, the e-newspapers, or a lot of them in the UK and elsewhere, will be available behind a paywall. And that means that people have to subscribe to gain access to it. And even the ones that aren't available behind a paywall will have restrictions that normally will allow people just to be able to read it on screen, but not do anything else, because anything else would then undermine their business model. So the answer is it's probably not legal, but if you really want to check the terms and conditions of the website, and hopefully that should clarify what you can and can't do. And if it doesn't, if you do want to download a whole e-newsletter for anything more than personal use or newspaper, then I would suggest that you contact the newspaper publisher and just make sure that your use is allowed. Or what does that mean? A license or a cost, a fee, something like that.
Thank you very much, madam. Thank you for answering all the questions of the participants. And it has really been nice to listening to you on copyright. You have given really a very nice covered whole information related to copyright, and it will be definitely useful to all the participants, and we'll definitely see that how we can make use of it, and we will also stick to whatever you suggested in your slides. So thank you very much. Thank you very much for accepting our request to be the speaker today and enlightening all of us on copyright. So once again, expressing my sincere thanks on behalf of all the participants and my own behalf. Thank you very much.
Thank you,
Thank
DP.
you. Stay happy and stay safe, madam. Thank you.
Everybody too. Thank you. Bye-bye. Thank you.